Okay, good morning, and welcome to a session of oral argument at the Fifth District Court of Appeal. I'm Judge Evander. I'll be presiding this morning. I'm joined on the panel by my colleagues, Judge Eric Eisnagel and Judge Mary Alice Nardella. We're here on case of South Florida Injury Centers versus Progressive American Insurance Company, case 21-630. These arguments are being live streamed and also being recorded. If you have any electronic devices or any cell phones, make sure you have them in the silent mode so that the oral arguments are not interrupted. Mr. Barr, I know you're familiar with this. How much time do you wish to reserve for rebuttal?
5 minutes, please.
All right, I'll try to help you in that regard. Also have a clock to assist you. And with that, Mr. Barr, you may proceed.
Good morning. May it please the court. Judge Evander, you forgot to remind us to take down our visuals in the back so they don't fall down on us during our arguments.
But I do like your background. It's very serene. Mr. Hazuri, I don't know, yours kind of a little more difficult there as far as serenity.
The third DCA, is it a competition thing? Is it? Sorry.
Well, hopefully you'll find the arguments today as entertaining as the last arguments that you presided over. I know Mr. Hazuri and I have spent a lot of time on this case and this issue. It's very important to both of us. We're here asking the court today to reverse the trial court's final order of dismissal for two very important reasons. First, we do believe that the amended complaint did state a claim for declaratory relief pursuant to Chapter 86 of the Florida statutes. And even if it didn't, we believe that the trial court abused its discretion when it did not allow South Florida Injury Centers to amend its complaint to address the trial court's concerns. So with regard to the first issue really brings up two questions, the first one being procedural and the second one being substantive. So I'd like to start with the procedural aspect first, and the best place to start is with the law and what the law says. So first we have the law regarding deck actions, and pursuant to Chapter 86, trial courts are vested with jurisdiction to declare rights, status, and other equitable and legal relations, whether or not further relief is or could be claimed. And then we have the law with regard to motions to dismiss. And when we're talking about a motion to dismiss a declaratory judgment action, the question is not whether the petitioner will ultimately succeed, but whether the petitioner is entitled to a declaration of rights at all. Now, the original order granting Progressive's motion to dismiss simply stated that the plaintiff failed to demonstrate that it's in doubt as to any right, status, immunity, power, or privilege. The court didn't explain what it meant by that. It just used those buzzwords and granted the motion to dismiss. We did file a motion for rehearing and motion for clarification. And the amended order, interestingly, went much further and then subsequently reasoned that the amended complaint failed to state a claim for declaratory relief because the complaint did not specifically state that Era Marshall was not a dependent of Michael Marshall. And we obviously—
Let me ask you this, Mr. Barr. If the complaint stated, plaintiff acknowledges that Mrs. Marshall was a financial dependent, any other definition of the word, but nevertheless, we are seeking a declaration of our rights under the contract, what would the issue be in that scenario?
I want to answer your question. I'm not sure that I understood the first part of it.
Well, let's just say you in the complaint, there was a statement, an allegation that Mrs. Marshall was a dependent, financial or otherwise. What else in the complaint was the plaintiff seeking to have the trial court declare as far as, the rights under the contract, et cetera?
I think the other issue that really needs to kind of be ferreted out, and perhaps it could be more clearly articulated in the complaint, but the other issue is that we believe Progressive can't produce any documentation to demonstrate that Michael Marshall selected a PIP deductible at all. So all we have is so we have this application that Progressive attached to the motion to dismiss. We have these documents signed by Michael Marshall, but there's no document indicating that he actually selected a PIP deductible at all. So I think that's an issue that was attempted to be raised. It's up to the court's conclusion whether it was sufficiently raised, but I do think that's an issue that even if she was, a financial dependent of Mr. Marshall, we could still argue that Progressive has no proof and there's no election of a deductible at all.
Attorney Carr, if you have the complaint up or the amended complaint up in front of you, what paragraphs would you point us to where that's put at issue?
Well, I would just point to, again, I think it could be more clearly articulated. But I think if we go to the wherefore clause, and the first item in the wherefore clause is asking the court to declare that no deductible is applicable to this claim. So again, even if the court doesn't believe that it was sufficiently pled, certainly we should have been given an opportunity to plead it through an amended complaint, which that argument was never raised by Progressive below whatsoever. And the trial court did not make any findings with regard to the required elements for refusing to allow someone to amend, which every district court of appeal is held as an abuse of discretion. So with regard to the question of whether or not Aaron Marshall is a dependent of Michael Marshall, we believe that we sufficiently pled what we needed to under a declaratory judgment action. We pled what Progressive's position is. We pled what our position is. We pled that there was doubt as to whether or not the deductible applied to Aaron Marshall. We also alleged that it was unreasonable for Progressive to assume that the spouse of a named insured is automatically a dependent resident or dependent resident relative, even though that wasn't really Progressive's position below, because as I'll get into here in a few minutes, Progressive's position below was very, very particular, and the trial court's order went well beyond what Progressive ever argued below.
Yeah.
We argued that there was an ambiguity between the insurance application and insurance policy. We argued that the insurance policy violated the Florida statutes, and we argued that the Progressive applied a PIP deductible when it should not have, that it wrongfully adjusted the claim. And in our wherefore clause, we asked the court to declare that no PIP deductible applies, that Progressive is not permitted to assume that a named insured spouse is automatically a dependent of the named insured. We asked the court to construe all ambiguities, and we also demanded supplemental relief as well. So we believe.
Let me go back to my hypothetical. And again, I understand it's a hypothetical, including the language in the complaint that saying that, acknowledgement that Ms. Marshall is a dependent in any sense of the word. But the application on page 2, on the PIP deduction, it says personal injury protection. Underneath that, it says deductible applies to you and dependent relatives. And it has deductible $1,000, $1,000 / person. And then apparently Mr. Marshall's initials are at the bottom, and apparently his signature is at the end of the application. So is that sufficient? Or are you saying that's still insufficient as to whether if Mrs. Marshall was in fact a dependent? And I tend to agree with you. I think the trial judge got it wrong on the financial versus dependent in some other vague manner. But even if we use even if we use the term financial dependent, why wouldn't that be sufficient on the application on page 2 if there was no dispute, and that's the part that's hypothetical, that Mrs. Marshall was a dependent relative?
I think because the statute 627.739 requires the insured to make an election, not only as to whether there's a deductible, requires the insured to make an election as to the amount of the deductible, and it requires the insured to assign or to elect who the deductible is going to be applicable to. And in this case, there is no such document whatsoever. There's no such election. There is an uninsured motorist rejection form, which is also required under the law. There is that form in the application, but there is no form indicating any manner of deductible being elected in any amount or to who it will be applied to in this application package. So while that might exist, we're at the motion to dismiss stage, and our position is that at a minimum, Progressive can't produce anything to demonstrate that Mr. Marshall elected a PIP deductible in this case, much less that it should be in any dollar amount or applicable to any particular person.
So if this was Mr. Marshall's case, not Mrs. Marshall, you'd say there's still no documentation that he chose a deductible?
I believe that we could assert in a deck action that Progressive does not have anything to demonstrate that Mr. Marshall elected a PIP deductible by virtue of the fact that they can't produce. And we believe that the discovery in this case is going to demonstrate that they have no such document whatsoever. So there's no document that demonstrates that a deductible was actually elected.
I mean,
Now-
in that case, why wouldn't your client have to allege that he did not?
Well, so our position with that is that it's a deductible as a limitation on coverage. So it alters the point at which coverage kicks in. We've alleged that a loss occurred during the policy period, and we believe that we've satisfied our burden with respect to that. Progressive is the one who is asserting that there's a limitation on coverage or an altering as to the point of which coverage begins. So we believe it's actually Progressive's burden to demonstrate that it has that the insured elected a PIP deductible and in an amount and to whom it was applicable to.
Well, if your client elected a deductible, then there would be no controversy on this issue, correct?
I believe if the discovery established that Mr. Marshall elected a PIP deductible, then that would resolve the issue. But that
Right.
would be the,
So in order to allege a controversy, don't you have to at least allege it?
well, what we've alleged in this case is that Progressive systematically applies a PIP deductible to the spouses of named insureds without regard to whether they're a dependent or not. And in
I mean,
this-
let's say that's true. In order to have standing here, in order to allege a dispute, don't you have to say, and in this case, she is not a dependent? Don't you have to say that?
I believe that, again, not the most artfully done, but I do believe that we've alleged that there's a controversy with regard to whether she is a dependent of Michael Marshall. And I think we've done that through the allegations, through the wherefore clause. But again, Judge Eisenhower, if you have questions about whether we've sufficiently pled that, I believe that goes to the second point, which is certainly we could have included those words, and we should have been allowed to do so in an amended complaint.
Well,
Where's
we'll
the-
get to second issue in a second, but going back to the amended petition, and I think, it is kind of vague in some of its allegations. We agree there's no allegation that says Mrs. Marshall was not a dependent. We
Those
agree there's
precise-
no specific allegation on that.
Those precise words are not included in there.
And would you also agree there's no precise words that say Mr. Marshall was not provided and did not have the opportunity to choose a deductible?
I agree that those precise words are not included in the amended complaint.
Okay, and I also agree with you that if the judge had given you an opportunity to amend, that'd be pretty easy to correct one way or another. So let's talk about preservation, because that was a very, I thought, odd way to phrase a motion for rehearing. Could you clarify these things as opposed to just coming out and saying, we request an opportunity to amend?
Yeah, I think the issue sometimes gets to the point where we have trial attorneys, and trial attorneys don't always understand the way things should be worded to be clear for appellate records. And sometimes appellate attorneys don't always understand how things should be worded and made clear for trial attorneys. I know in this particular case, it was unclear when the court entered its generic order as to whether or not there was leave to amend, whether or not it was with or without prejudice. And so we wanted it to be clear. We wanted to be clear whether we had leave to amend. And the court not only made clear that we did not have leave to amend, but the court went far beyond any arguments that were ever made and dismissed the case with prejudice, essentially saying, I'm deciding this issue on the merits, and you can never plead anything that would allow you to prevail in this particular case. So while I agree that it's perhaps unconventional, the court did rule on the motion. The court did enter a subsequent order, and the court did find that we did not have leave to amend and dismiss the case with prejudice. So I believe that we've preserved that issue, and I wholeheartedly disagree with the invited error doctrine raised by Progressive in this case. And I think that asking for clarification, I just think it's just incorrect to argue that that's invited error in this particular case. So I did just want to touch on in my last a minute and a half or so. We also believe the court obviously was substantively wrong with regard to what dependent means. We believe the Lumberman's case directly addresses this. I just want to point out that Progressive's argument below, interestingly, Progressive didn't even think the word dependent appeared in the statute. So they argued this entire thing about resident relative, and then the court not only disagrees with with our client's position, but then the court goes beyond any argument presented and creates its own definition of dependent in order to.
What's wrong with the court reading the statute and interpreting it? I mean, I guess you lose me there when you start making that argument. I don't understand.
Well, Lumberman's already interpreted the statute, so Lumberman's was binding on the trial court. So,
But it's not binding on us.
it absolutely is not binding on you. But the issue is we have to look at why did the court insert the word dependent into the statute in the 70s? And the clear answer to that is because.
But counsel, it sounds like you're going into a legal argument, which I think is appropriate. It sounded previously like you were sort of being critical of the trial court for it going into this, what appears to be a legal analysis. So I guess I don't understand why the trial court was wrong to interpret the statute.
Well, I think the trial court, where the trial court got it wrong beyond the substance was the trial court was essentially advocating for Progressive because it was taking a position that Progressive did not take in this case. And so we believe that was
when there's a lack of, is that improper when there's a lack of standing? I mean, if nothing else, in the declaratory judgment sort of situation, you have the gatekeeper function. Why would that be inappropriate for the court to say, look, I don't even see in the gatekeeper function, I don't even see a dispute here.
Well, it was more so that the court was finding no dispute beyond the reasons proffered by Progressive. And I think that simply disagreeing with us is one thing, but when the court went and created its own definition of dependent beyond what anyone had argued in this case, and that resulted.
But the definition of dependent is a legal issue, right? That's within the jurisdiction of the court. The court doesn't have to agree with either side on the interpretation of the statute.
The trial court was bound by Lumberman, so that's not even a question. I think that the trial court had the ability to answer.
Right, but we wouldn't, if we disagreed with Lumberman, we wouldn't reverse just because the trial court, would we? Would we reverse would we say Lumberman was wrong, but the trial court should have followed it, therefore we reverse?
No, but it just goes to the point that things had gone awry at the trial court level. And I think that the order was entered and it went beyond the scope of any argument, and it shouldn't have. And I don't want to go too far down that path and assume anything about the trial court's reasoning, but we just believe that it was improper advocacy. The court was bound by Lumberman's. This court is not bound by Lumberman's, but Lumberman's was well decided and fits perfectly in with why the statute was amended in the 70s to add the word dependent. And so I'll reserve the final 3 minutes I have for rebuttal. Thank you.
All right, thank you. Mr. Hazari.
Thank you, Your Honor, and may it please the court, Ken Hazari here for the appellate Progressive. And I would start with the hypothetical that you raised, Judge Vander, which I think was elaborated on and added to by Judge Eisnagel. I think those points that you made to Mr. Barr were intended to illustrate that if Mrs. Marshall is indeed a dependent of Mr. Marshall under the statutory definition, then we have no dispute here. There's no issue. The deductible was properly applied. They have made it very clear that they did not plead that Mrs. Marshall was not a dependent of Mr. Marshall, and that the case has nothing to do with that. On page 2 of their reply brief, they say the fact that SFIC did not allege that Aaron Marshall was not a dependent of Michael Marshall is not fatal. Just concede they didn't plead that. In their initial brief, they talk about how.
Counsel, why not? Why shouldn't they get a chance to amend though?
We can move to the amendment issue, sure. It's the first part is they invited the error and they didn't preserve the argument.
Let me ask you this, Mr. Hazari. If they had said, we request the opportunity to amend the complaint and did so clearly and specifically, would you agree that it'd be abuse of discretion in these facts to deny it?
No, for the second part, argued based on the reasons argued in the second part of that argument in our answer brief, the court, we believe, was within its within its discretion, its very broad discretion when exercising its gatekeeper function, to determine that this type of deck action as pled by them was not worthy of the use of.
So what if they
judicial
came
resources.
back and were given, I mean, if they said, Judge, we seek leave to amend, and we will put in a specific sentence that says that Mrs. Marshall is not a dependent as defined by the statute in any form. What, would that be sufficient?
That
To create a dispute?
Well, you'd have to see what the rest that they pled was. I would answer the question more specifically as no for the other reason set forth in our brief, and that is that the court found that their argument under the statute 627-7391 was legally incorrect, and that they were proffering an argument for dependency that was legally incorrect. So you basically have a futile, it would be a futile amendment based on.
Or do you believe the trial court's analysis was consistent with Lumberman's? Because it kind of seemed to me to be the opposite of what Lumberman's held.
I don't think so, Your Honor. And I get, you have to, I would submit that you need to, that Lumberman's, assuming the court is going to agree with it, Judge Eisnagel has indicated, perhaps that's not the case, not to put words in his mouth, but you have to read all of Lumberman's to get the full flavor of it. Now, the court, to the extent the court said, well, it's not just financial, or it's not financial, I get that Lumberman's talks about financial dependence, okay? And I understand that financial, under the Lumberman's analysis, financial dependence is a component of this. But Lumberman's also says, more importantly, as the Acostas point out in their brief, when an owner purchases personal injury protection, he is making an economic decision for himself and his dependents. And then skipping down a little bit, and they talk about how you can save money on the premium by getting a deductible for you and your dependents. And then it says the non-dependent relative would presumably carry the burden of making his own arrangements against the risk of accidental injury. It is perfectly logical, therefore, that non-dependent relatives are excluded from the optional deductible. So in this case, if you apply that language, which the court did, of Lumberman's, you have Mr. Marshall purchasing personal injury protection on behalf of himself and his family, including Mrs. Marshall. And just by that very fact that he's going out and
Lumberman's
he's handling that, doesn't that, I would submit that
Lumberman's rejected the idea that the other person was a dependent for purposes of procuring insurance. I mean, didn't they specifically reject that idea and went to a financial dependent?
They did, and in doing so, they issued the holding that I just read. So what the holding I just read is not a holding that somebody's dependent for insurance purposes. It's analysis of how you determine whether somebody is financially dependent in whole or in part.
So if
Because that's
Mr.
what the court
Marshall
ruled.
was unemployed and Mrs. Marshall was making, $200,000 a year, and they allege that in the complaint, it'd be your position that they still don't qualify under the statute?
Well, see, we're opening up a huge can of worms here.
Well,
Okay,
no,
he's
I'm going to the
well,
amended-
I'm
I'm
going
going
to
to
answer
the
your question. Was he
I'm going to the
unemployed at the
amendment
time he
aspect.
purchased?
When you answer the question, also tell us how the insurance company would possibly know if someone is making $200,000 a year.
Well, that's just it, Your Honor. This type of argument is requiring some sort of intrusive.
Wouldn't you have a trial? You would have a trial in every single case.
Absolutely. Anytime a deductible got applied to anybody other than named insured, then we're going to have a PIP suit.
You're going to
It's gonna
trial.
be, give us your tax returns, Mr.
Pick
and
the
Mrs.
jury.
Insured. Were you employed at the time? How much were you making? How much were you making, Mrs. Insured? Did you file your own tax returns? Incredibly intrusive financial discovery.
Here's the concern I have with Lumberman's. I imagine both counsel will address this, but it seemed like they latched onto a dictionary definition, and that's it. There was no analysis of no impressive analysis anyway of the context of the statute or the context of the situation when one purchases insurance. And so that was, to me, that was the weak part of Lumberman's, is the failure to consider any sort of what seemed like context and just latching on to a dictionary definition. Am I on there, or am I missing something?
You
about
certainly
lumbermen?
could be. Certainly could be onto something, not missing something. There was a dissenting judge. Judge, Judge Eisnagel, if you're of the
Well,
thought process that
we're-
perhaps a dissenting judge had it right, then you could be
When we're
onto something.
interpreting statutes, aren't we required to consider the context, the statute in context? I mean,
I think so. If it's not explicitly clear what something,
well, we have,
you
I
know,
mean,
we know
we
the
have-
plain
yeah,
language and all that,
we
but I
have-
don't think that applies.
we
here.
have recent cases saying, yes, we have to consider the context, right?
Sure.
So,
Sure. And again, if you wanted to give lumbermen's a little more, from your perspective, it sounds like possibly Judge Eisnagel benefit of the doubt. You read the definition they use, the dictionary definition is depends or has to rely on something else for support, supply, or what is needed. That's broader than just Mr. Marshall's the sole breadwinner and he brings home all the money. And so everybody else is dependent on him. And the trial court, hit on that. They said, a husband and wife, they provide support to each other, especially,
Well,
raising a child and
dependent
everything
means-
else.
Dependent means something under the statute, right?
Yeah, yes, Your Honor, it
I
does.
mean, if this was a minor child, it might really be easy. And of course, the easy way to avoid this is if both spouses are named insureds. I mean, I don't know why that didn't happen here, but that's certainly the easiest way to deal with the situation.
I
but-
don't know the
But
answer to
dependent
that.
has to mean something. The IRS uses the term dependent. It's got to mean something, because my concern is if you go fully with your argument, then dependence kind of being wiped out. The word dependence kind of wiped out the statute. I agree the statute raises more questions than it answers with the use of the term dependent, but.
Okay, Your Honor. Fair, I would submit to you that husbands and wives, especially when their parents are accepted in the most extreme example I could think of, where somebody is a billionaire and somebody's doing actually nothing, maybe, but then the wife may help raise the children. Maybe it's the wife who's the billionaire, to not be
Right.
politically
Right.
incorrect here, and the husband raises the child. Husbands
Well, I mean,
and
look,
wives provide support. and
counsel, I mean,
dependency to each other.
regardless
I mean,
of,
that's how it works.
who makes what in between the spouses, let's say that, the spouse that makes $100,000 a year has great insurance. And the spouse that makes $500,000 a year decides it makes financial sense to have that insurance, right?
Get on that plan, yes.
So what happens if under lumbermen, if we say, well, that, hey, it's pure financial dependency, does that cut off the ability of the spouse making $500,000 a year to just use the other spouse's insurance?
That would be a problem. I would agree with you, Your Honor. That's the issue here, by just, strictly making this something, strictly financial, as you said.
I mean, it
Because
would
there's
be
lots of
workable,
ways that spouses support each other, and they can have monetary consequences or not.
but it
Well,
would
the term dependent really only comes up in the terms of PIP deductible, right? Otherwise, the policy controls, and there's a named insured, and the policy says who's covered and who's not covered, and has exclusions and whatnot.
It does come up in the PIP deductible. I can't tell you I'm well versed enough to know for sure it doesn't come up anywhere else. I haven't focused on that because we're dealing with a PIP deductible here, but your point is, I get your point there.
why would the legislature say, hey, look, this limited set of people can have a deductible? And I think I know the answer to this, but I just want you to tell me.
I'm glad you asked that question, because I was trying to get my mind on track to
And
explain
this,
that.
counsel, this might go to context.
You queued it up for, yes. PIP coverage is very broad. There's a set of insurance called omnibus insurance who can receive PIP coverage. If I have somebody driving in my car and they don't have a vehicle and they don't have PIP coverage, and they're not required to have PIP coverage, they don't have an operable vehicle, and I get in an accident with that person in that car, they can seek PIP coverage, and they're not related to me or anything. They can seek PIP coverage under my policy. So what it's designed to do, I would submit the context that you're talking about, Judge Eisnagel, is when you're dealing with these pure omnibus insureds, which is, by the way, what the adult children were in lumbermen's, who get coverage under the policy through this omnibus situation, not because they're a resident relative and a dependent. That's who the named insured cannot designate a deductible for. That's what I believe is the intent here and the purpose of that, and that's in our brief. And
that wouldn't that kind of make sense that that the named insured could not choose a deductible for that type of person?
absolutely, because that person is could be a total stranger to the situation.
Right. It's different than a resident relative, right? I mean, it's a very
100%.
different deal.
A resident relative who is in your household as a relative, and the named insured, in this case, Mr. Marshall, has gone to an insurance agent and said, I'm going to get insurance for my family. Please give me this. And as noted by Judge Vander, it's right there in the application, PIP deductible $1,000. That's an entirely different situation. There's no.
Counsel, why isn't the motion for a hearing enough to preserve the opportunity to amend?
Because of, excuse me, the qualification they put in there and the additional language they put in there. They said, I'm paraphrasing, one possible interpretation of the court's original dismissal order was that they felt that it was a finding, it was a pleading defect, that they failed to adequately plead doubt. And they specifically say, if that is the case, we would like the opportunity to amend. So they told and then the rest of the motion goes on to say, otherwise, just clarify your ruling so we can have a clear record for appeal. So when you read the motion for rehearing is, we want to amend if we only need to reallege doubt. Otherwise, just clarify your ruling for appeal. And that's what the judge did. So they invited the judge to rule exactly as the trial court did, dismissing the case with prejudice, because the judge's ultimate ruling had nothing to do with them not pleading they were in doubt sufficiently. So they took the exact invitation that was given to them by the plaintiff's counsel, trial counsel in the trial court. And, respectfully, Mr. Barr's statement that, well, trial counsel doesn't always know the rules of preservation, not sufficient to overcome that. That's why, appellate attorneys and trial attorneys should work together.
That's probably not sufficient, but doubt is a pretty broad term, right? I mean, in some ways you could say, well, the fact that we didn't allege that she is not dependent, we haven't established any doubt.
I don't take that as what the court's ruling was or what they were asking for. The court's ruling, again, as we talked about, interpreted 627, 739. That's a legal ruling under the statute that has nothing to do with doubt. The court rulings, noted, in fact, the ruling on page, 149 of the record, which is page 4 of the order, the ultimate order that was entered, goes through great detail, knocking out all the things that they're not alleging in this case, and saying basically they're trying to focus on Progressive's claims handling procedure, which is improper. And I don't think any of that has anything to do with a failure to plead doubt. I think that the court, under its gatekeeping function, found that the entire nature of the deck action that they were trying to bring was abstract, conjectural, not a bona fide dispute, not a bona fide controversy. That is a totally different issue than failing to simply plead doubt as to a particular right, in my view.
Well, let me ask you this on issue 1, and then a separate question for issue 2. What is the standard of review for this court?
I think that's a great question. We've laid it out in great detail. That they're, in our view, under the Rabaya case, which recognizes the second DCA case. You guys aren't bound by it, but I thought it contained a real solid analysis of harmonizing the various cases that talk about abuse of discretion and de novo review in this. There's 3 different standards of review that apply from our view, based on the various rulings in the trial court's order. The first is if you're simply going to rule that it failed to state a cause of action, that's de novo. The second, which really comes to the forefront, is the gatekeeper function, which the Rabaya case says, and seems to be consistent with this case, with this court's decision in Palumba, that talks about giving great deference to trial court rulings on motions to dismiss deck actions. It is, even if the complaint is technically legally sufficient, which this one is not, we submit, the court can look at it and look at the situation and say, this isn't a bona fide dispute. This is not a bona fide controversy. And the reason that discretion rests with the trial court is because the language, and again, all in Rabaya, the language of the DEC action chapter is pretty broad and allows, DEC actions to be brought in a broad set of circumstances, not unlimited though. So Rabaya says we give the trial court the discretion under the bona fide controversy and bona fide dispute prongs to say, even if this is technically states a cause of action, this is not a good use of judicial resources. And I know you had another question for me, Judge, real quick. All of this could have been resolved and been very clear if they would have just filed a suit for PIP benefits. Mrs. Marshall was not a dependent relative, pled explicitly in the complaint. Progressive misapplied the deductible to her. Progressive owes additional PIP benefits. They didn't want to do
Let me ask
that
you this,
because
if they file the breach of contract, fail to pay PIP benefits, then your client can file a proposal for settlement and arguably can turn the one-way attorney's fee provision under the statute for all practical purposes into two-way. With the DEC action, you don't have the opportunity to file a proposal for settlement. Would that be correct?
that is their goal in doing it. There is some case law that talks about when a DEC action, the actual claim is to recover PIP benefits or to recover damages, that there is some, I'll call it wiggle room to do a proposal for settlement in those cases. That wouldn't apply here because they called it a pure action for declaratory relief in order to avoid Progressive's ability to serve a proposal for settlement, and also to avoid the necessity of serving a pre-suit demand under subsection 10 of the PIP statute, which we all know is designed to limit and reduce litigation. So they're trying to make an end run around that by filing a pure act, quote unquote, pure petition for declaratory relief that doesn't allege a real controversy.
By doing that, they arguably subject themselves, maybe not in this case, that'll be my next question, but by doing that, they subject themselves to the ability of the trial judge to exercise a gatekeeping role.
That's exactly right, Your
But
Honor.
in this case, does the gatekeeping role come into play based on the order granted by the trial judge? The trial judge grant this motion to dismiss under a gatekeeping role or solely under an insufficient complaint?
No, I think that it was clearly done under the gatekeeping role. In addition to, I think there were multiple rulings, but I think the gatekeeper role was clearly applied here by the trial court. And again, I would direct Your Honors to page 149 of the record, the language of the order. I'm running out of time. I know that begins with, there is no dispute that Aaron Marshall is related to the policy holder by marriage, and it goes and talks about all the disputes that are missing. And the judge talks about the slender reed upon which plaintiff supports this case is the claim that defendant presumes the spouses are dependents, as stated in 627-7391. So the court recognizes they focused this on Progressive's claims handling procedures. That's irrelevant. They did not plead that she was not a dependent, and therefore this case is a ephemeral, conjectural DEC action that doesn't justify the use of court resources. That was essentially what the ruling was. So there was a gatekeeper function ruling.
All right, your time is up. Thank you, Mr. Missouri. Mr. Barr, rebuttal.
Thank you.
Thank you. And I just had 3 points I'd like to make just real briefly. Judge Eisenhower, you asked about context. We believe that the deductible statute 627-739, the context is financial. We believe the PIP statute, the context is financial. We believe a lumberman's case was decided based on the proper context of both of those statutes, which is financial. So financial dependence is what the legislature meant when it included the word dependent into.
When you say it's fine, the context is financial, what could you elaborate on that? What do you mean by that?
Absolutely. The PIP statute is designed to provide prompt payment of medical expenses so that insureds can get on with their lives. The deductible is designed to alter the point at which the PIP coverage kicks in. Both of those are financial. They're wholly financial. That's all they are, is about.
I mean, wouldn't all insurance coverage then on some level be financial?
Absolutely.
Okay.
Absolutely. And so the second point being, Judge, you asked, well, wouldn't we have a trial in every case? Well, we would have to have a trial in every case, regardless of whether the court adopted the trial court's definition of dependence or lumberman's definition of dependent, because the fact of the matter is Dependent was added to the statute in the 70s to alter resident relative. Resident relative is what Judge Eisenhower, you're asking about now, which is you live with someone, so therefore you're part of the household. That was altered. That was altered by the legislature. This court cannot presume that it means the same thing now after it's been altered by adding the word dependent. It means something different. And lastly, the court asked, well, how do you avoid this whole issue? It's very simple. Judge Evander, you hit it. It should list as a named insured. Secondly, the application can ask, who are your dependents? Who are your dependents? And there you go. You resolve the issue. The IRS knows how to do it. The family law forms know how to do it. They all talk about financial dependence. How do you list someone as a dependent?
So you agree that it would be enough for the named insured to represent, these are my dependents?
I believe that would significantly limit our ability to challenge.
Yes or no? I mean, would there still be an issue of, well, the other spouse makes $500,000 a year and therefore is not dependent? Or would it be conclusive if the named insured said, here's my list?
I don't know if it would be conclusive, but I think it would significantly alter the ability to make the argument that Progressive can't prove one way or another whether or not they're dependent. And what they're doing is systematically applying a deductible to a spouse of every single named insured. So regardless of how you define dependent, you're going to have a trial in every single case. And so by looking at Lumberman,
is the statement in your motion for rehearing about the, hey, if we fail to allege doubt, then we want a chance to amend, is that the best example of preservation of your request to amend, or is there a better one?
I believe simply telling the court that we wanted leave to amend to address the court's concern is sufficient, and that's what we did in the motion for rehearing. And so we would ask the court to reverse the final order. Thank you.
Thank you both for your arguments. Well done. The court will be in recess.
Thank you, Your Honors.